Oldies 98.9, I'm sure you remember that one from Sugarloaf. Yeah, Green-Eyed Lady. I had to go out and buy that 45. It is a Hump Day Wednesday, giving you the greatest music ever recorded. And, of course, special guest with me this morning. He is just such a professional. He really is. Richard J. Shapiro, elder law attorney. Oh, yeah. Richard, welcome aboard again.
Hey, thank you, Bob.
It's nice to be able to talk to you.
Same here.
Yeah, so, Richard, this is basically it's elder law, but basically it's about getting everybody to get their ducks in a row for end-of-life planning. Isn't that correct?
Certainly a wise idea, yes.
Yes. And where are your offices located, your phone number, and your website?
Sure. Offices are located in Goshen at 10 Matthew Street, in Warwick at 20 Oakland Avenue, and up in Monticello, which I don't actually remember the exact date. Street is on Main Street. I know that.
Okay.
Phone number 845-291-0011, and our website is mid-hudsonlaw.com.
All right. So, there's a lot of things about elder law that people really have to know. What would you say is the right age to get your act together with a last will and testament and so on and so forth?
Well, I always like to tell people, half seriously, half joking, that when you know you're going to die, call me 6 months in advance and we can do the planning for you.
Oh, man. Yeah. No.
But in a more practical answer is certainly when you have a child initially, the biggest issue people have is not so much a lot of assets, but they want to appoint the appropriate guardian. They maybe want one grandma to be the guardian, not the other one, or something of that nature. So a last will is where you would designate that information. So you should do something even if it's a rudimentary plan, after a child. Beyond that, once you start accumulating assets, hopefully you do, sometime in your early to mid-50s is when you should absolutely be looking at that, as you're getting hopefully closer to retirement than to the start of your career, and you really need to think about, those kind of issues because, of course, your mortality is what it is.
I know what's on everybody's mind, and, of course, that is the Powerball drawing tonight for $1 billion. Can you imagine $1 billion?
Yeah, it is quite shocking. Yeah.
Well, isn't it though? And then, of course, the Mega Millions is up there too. I think that's like over $750 million. So, let me ask you this question: what if an individual wins this in this state of New York, and after taxes, et cetera, ends up with a little over $500 million? Can they put that in their last will and testament for somebody to, collect those winnings?
Yeah, certainly. The winnings are part of your estate. Obviously, if you receive a lump sum payment, you can take those and invest them, and then however your will says your estate passes, that will be part of that, unless you specifically designate a particular account to one or more people. If you're taking the periodic payments over a period of years, which frankly is not how I would do it, I would take the lump sum and control the investment myself. But be that as it may, many people do take the periodic payments. If you do that and you pass away before you've been paid out fully, then the balance will be paid to your estate, and then therefore under your will, whoever is the beneficiary or beneficiaries of your estate will share in that.
Oh, wow. Now, what if that account with all those millions in it has only one name on that account, which just in this particular case would be the deceased? Can anybody access that account, like maybe his spouse or her husband?
No. Until either an administrator or executor is appointed, no one will be able to access those funds, and that's where the probate process kicks in. At that point, the estate would need to be administered through the surrogate's court in the particular county in New York where the decedent lived. And then once the fiduciary person was appointed, then they would be able to count and distribute them the funds either according to law if there was no will or pursuant to the terms of the will.
Wow. And about how long would that process take, Richard?
That depends on many factors. If it's a simple process, let's say you have a spouse and adult children who are all on board and no one's estranged, etc., it could take just a matter of a few weeks, 4 or 6 weeks from start to finish once the papers are filed. If you have other complicating factors, minor children who need to have attorneys appointed for them under what's called a guardian ad litem process, or if you have missing or estranged children, then the process can be much more dragged out and go on for months or years even.
Wow. And of course, nobody wants to see that happen, especially. So,
Yeah.
With people sitting back in their recliner or on the couch within the sound of our voices here, what if nobody has done anything for, their end of life plans, and that person just happens to pass away? There are no children, there are no grandchildren, nothing. What happens to their estate? Like the house, the car, money in the bank.
Are you saying are they married or not married in your hypothetical?
No, they're married. Yeah.
Okay. Well, that should be fairly straightforward. In that case, under New York law, if there is no will, then any individually owned assets owned by the deceased will, by law, pass to the spouse once he or she has filed the paperwork with the court and been appointed as the administrator of the estate. Then they'll have full rights to those assets.
Boy, I mean, is it me, or is this state really complicated with law like that in regards to the deceased?
No, every state has a process for intestacy. Intestacy is the term that refers to a person who dies without a will. And every state creates an intestacy pattern of distribution. They may vary somewhat from state to state, but they're fairly similar in most states that I've researched.
Huh. Now that's very, very interesting, because in my times of talking to you, me personally, I'm really confused about a lot of this stuff. And I'm sure a lot of people are too, and that's why they need to come in and talk to you about this.
Well, we certainly create solutions to problems that sometimes people don't know even exist. And unfortunately, these problems often arise after a person has died, and then their heirs or their prospective heirs are stuck with a mess.
Yeah, we don't want that to happen. Richard, I got to take a quick break here. Can you hang on and come back and join us?
Sure thing.
All right, stay right there. Richard J. Shapiro, of course, Elder Law, right here. And he'll be right back with me after this. I love them. I really, really did. Hey, it is a Hump Day Wednesday. Good morning to each and every one of you. I'm Bobo across the Hudson Valley and worldwide at WGNYFM.com. And again, we welcome Richard J. Shapiro, elder law attorney. Richard, good morning.
Good morning again, Bob.
Yeah, thank you so much for hanging in there and coming back and talking to us about this very, very important issue, end-of-life planning. Now, we covered a lot of ground the last break that we had, of course, from winning the lottery to, a bank account being in the deceased person's name, and things that people should have to do, and when you should really start your end-of-life planning, especially when you have a child.
That's correct.
So, let me ask you this. Where does a person begin with their last will and testament? I mean, there's a lot of ground to cover there. depending upon the individual's assets. You know, like a house that's all paid off, a car, maybe the car is being leased in that individual's name, the deceased, and a bank account, a joint bank account. What happens if that person happens to pass away unexpectedly and you have a leased automobile with another 2 years to go on the automobile? What happens there in that case?
Most times, you can typically work out with the car dealer or the auto leasing company to return the car if the survivor can't afford to keep it sometimes. But technically, that could be an obligation of the estate of the decedent. But if there are no assets, for example, then the car will just be ultimately reclaimed by the leasing company. But typically, people are able to negotiate returning of those cars, and that they still have presumably the value, and the leasing company can can resell them or release them. Other than that, so much of the ultimate result in this scenario when you have a deceased person is going to be driven by how they own their assets and what type of assets they were. And a lot of the disconnect people have is they think, they did a will, they did their basic will. We call them I love you wills, assume they have spouse and some kids and everyone's on good terms. And essentially the will typically would say, upon my death, all my assets pass to my surviving spouse, and then it passes equally to my 2 children. And that they did that will in 2002 and never thought about it again because it was done. But then over the course of time, they acquire different assets and they have different forms of ownership. And let's say that their spouse has now died, and they still have the will that says leaving equally between my 2 kids. But as they get older, we often see a scenario where, say one child is local and one is out of state. And as the parent gets older, they tend to often rely more and more on their child, the local child especially, to help them out with their daily affairs and their financial matters. Very commonplace. And often what happens is they end up, either through the suggestion of someone at a bank or otherwise, they just stick their child on their account as a joint owner for convenience typically, to allow that child to more easily access and help pay bills and so on. But the real problem with that is that when the parent now dies, that child is the sole owner of those assets by joint ownership, by rights of survivorship, and the other child gets none of it. Now, certainly, sometimes, many times, the children will, the recipient child will say, "Oh, yes, of course, that's intended for both of us. We're going to split it." But as many times as not, the other child, the beneficiary child, says, "Oh no, Mom or Dad wanted me to get that money. You don't get it." It doesn't matter what the will says in that case, which is true. The ownership trumps the terms of the will, and that's where a lot of these arise between siblings, and unfortunately, it leads off into a permanent rupture in the relationships between the children.
Now, what happens if the deceased has credit card debt, maybe $7,000, $8,000 in credit card debt?
It really depends on whether there are any assets. I have been called many times over my career. Child says, Mom died, and I'm getting all these credit card bills, and we haven't done anything. And my fundamental question is, did your mother have any assets? If she did, oh, yeah, she had a house and some bank accounts. Well, all right, then the creditors have to be paid off first with those assets, and then the rest will pass to the beneficiaries, whether, if there's no will through an administration, if there is pursuant to the terms of the will. But if the parent really had no assets and just had debt, the children are not liable for their parents' debt. They don't have to do anything. Ultimately, what usually happens is either the credit cards will just, once they are informed that there are no assets, they'll just eat that debt, which is why credit card interest rates are so high, because they end up eating a lot of debt in those cases. Or if they have a right to file a probate proceeding to determine for themselves if there are assets or not. And once they or a public administrator is appointed, if none of the children participate, then if there are no assets, they're still going to get nothing. But most importantly, from the children or the heirs' perspective, they are not personally liable for their parents' debt unless they have personally guaranteed those debts, which for a credit card is not something that usually would happen.
Well, there's another thing out there, too, that started, I don't know how long ago. It's called a reversible mortgage, where, mom and dad may have taken out a reversible mortgage. What happens there?
Well, under the terms of a reverse mortgage, it must be paid off within 1 year, typically, of the death of the person who took the mortgage out, the homeowner.
Really?
Yeah, but that's typically what's going to happen, because you should only be taking a reverse mortgage if you really have no other options in terms of lifestyle needs, and a reverse mortgage is a nice way to tap into equity in your home when you are short of income. If you're only living on Social Security and it's really not enough to have a decent quality of life, and you have a house worth $300,000 or $400,000, and you take out a reverse mortgage, you get a nice lump sum of money, and you don't have to pay it back during your lifetime. But of course, interest accrues during that period, and so when you pass away, the house will have to be sold, and the mortgage gets paid off first, and if there's anything left, then it can pass to the heirs. Many times, especially in areas when we have depreciation of real estate prices, we've seen cases where the reverse mortgage amount is now worth more than the home, and in that case, then again, the children have no incentive to bring a proceeding, and so it's up to the reverse mortgage company to start that process and ultimately get the house sold and take what they can get.
Boy, that sounds like a real complicated mess to me.
It can be.
So that's what you would take care of too, right? I mean, advising your client what to do based on that reverse mortgage. And
yeah, absolutely. If there's no equity in the house remaining, I'll tell the kids, and there are no other assets, which often is the case, because again, people taking reverse mortgage typically don't really have much in the way of assets, or else they wouldn't be taking a reverse mortgage in the average case. If the reverse mortgage is more or equal to the value of the home, I'll tell the children, don't do anything. There's nothing for you to gain out of this unless you can negotiate something with the reverse mortgage company and say, listen, I have no incentive as the child to bring a proceeding, but if you give me 10 or 15% of the net proceeds, even if you would otherwise be entitled to it as the reverse mortgage payoff, then maybe I'll bring a probate petition, and you might have some luck with that.
Boy, I'll tell you what, it's so good that we're talking about this, because people really need to know. And, of course, there are a lot of seniors out there that went and elected the reverse mortgage because they live on a very, very limited income and find it hard to make ends meet. So that's an area where they might have gone. Of course, they are responsible for the upkeep of taxes and, of course, the property. But the reverse mortgage, people just feel very secure when they do something like that. So, if there are people in the listening area here that have a reverse mortgage and you need some advice on something like that, contact Richard J. Shapiro right here. He is really a wonderful attorney. He's extremely professional. Richard, your phone number, how can people get in touch with you, your website, and, of course, your offices? Where are they?
Yes, we have our offices are in Goshen, my primary office, Warwick, and Monticello. Phone number is 845-291-0011, and our website is mid-hudsonlaw.com.
I mean, people can't just sit back and think, well, I made out a last will and testament 15 years ago. I don't need to do anything. They should really review that, shouldn't they?
Absolutely. No less than every 5 years it should be professionally reviewed. So just to throw this out, because it just occurred to my mind, we do periodic workshops, which we go through all kinds of estate planning information. We do have one scheduled for next Thursday at 3 p.m. in our Goshen office. People can register through our website, mid-hudsonlaw.com. It doesn't cost anything, and we give you a wealth of information that you can act upon thereafter.
Oh, wow. You have workshops, huh?
Yes, we do.
I think that's awesome. I think it's really, really awesome. Hey, can you hang with me here? We got to take a break.
Sure thing.
I would really appreciate it, Richard. Really do appreciate your time, too, by the way. Thank you so much. Stay right there, and we're going to be right back with more of Richard J. Shapiro right after the latest local news and ABC Spotlight Entertainment. Richard J. Shapiro is still hanging out, and definitely hanging on with us. Richard, I just want to say thank you so much for your professional time.
Oh, my pleasure.
Yeah. You know, we're talking about all these issues with the last will and testament. You really gave out some great information. Now, let's go back to your workshop. I didn't know that you guys had workshops.
Yeah, I've been doing them since 1999, so it's old news to me.
What? So just explain, if you would, for a minute, what does an individual do at your workshop?
Well, really, hopefully learn. We use PowerPoint presentation, and we discuss the different do's and don'ts of estate planning, and we get into Medicaid planning rules and protecting your assets if you need long-term care. So, typically runs about 2 hours and 15 minutes, and we really try to cover a broad swath of information so that people leave with information that they need to act going forward, whether they work with us or someone else. They at least be better informed about their options.
Well, having you on the air here is not intended to scare anybody, that's for sure, if they don't have any plans, last will and testament, revocable or evocable trusts. They got to learn all this stuff, really. I mean, it's much better off resting knowing that you're very, very well covered and protected when they get an attorney like you. That is, that's a big asset in itself.
Yeah, people sometimes get, paralysis by analysis kind of situation where they think, I have to know everything before I can do anything. The reality is you have to work with a professional that you are confident in, that knows his or her stuff, and they can guide you through the process. I mean, when I need surgery, I'd like to know the basics of what I'm doing, but I don't need to know the exact details of the procedure. And doing estate planning is like that too. You want to be educated so that you know what is being done or recommended is right for your situation, but leave it to the expert to put the work in and do the actual drafting and integration of your assets and so on. And you'll be much better served than just waiting till you know everything, because you never will know everything.
No, that's very, very true. And really, really a good piece of information and advice from you is that if you have a last will and testament dating back years, it's always good to review that. And you said you should have a review like every 5 years?
Yeah, at minimum. I mean, we even actually offer an annual review program called under our Legacy Assurance program, but not everyone does that or absolutely needs it. However, when we talk about reviewing your will, it's not just your will, it's your entire estate situation. And equally important to reviewing the legal document itself is actually reviewing the way your assets are owned and what those assets are, because that's where the biggest problems occur, as I alluded to in my hypothetical I mentioned a few moments ago. Your will only controls what you own alone. If you add someone else to an account or name a beneficiary of an asset that doesn't include all your beneficiaries, that will throw your estate plan out of kilter in most cases.
Now, what if the husband passes, and his wife is just left in the house, and there's two children, but the husband and wife have a problem with both those kids? Can those kids go after her assets?
Well, let's assume the house is jointly owned, as the vast majority case. So the wife, by operation of law, inherits the home. If she then has issues with the children, she can meet with an attorney and disinherit them entirely or partially, whatever she decides. The only person who you cannot fully disinherit without their consent is a surviving spouse. New York and virtually every state, I believe, has what's called a right of election, where a surviving spouse is entitled to a portion of a deceased spouse's estate, even if they've been left nothing in the will or a trust, and that's the elective share. But children do not have that right. A famous philosopher, as we may remember, called Ann Landers, always said, "An inheritance is not a right; it's a privilege." And I really believe that. Just because you gave birth to someone doesn't mean, if they've been horrible to you for years, that you need to or should be leaving them anything.
Well, like, my question is that if there's two children and neither parent really wants anything to do with them because it's Johnny Rotten, basically, can that child go after that estate anyway and bring forth legal matters?
Well, so here's there's many ways to answer that, really. So let's say that the parent really wants to disinherit that a particular child. Probably the best way to do it, and for other reasons, it's usually the best planning, is to have some form of a trust, either revocable or irrevocable, depending on their circumstance. And a trust assets that are owned in a trust do not go through probate, assuming the trust has individual or named beneficiaries within the trust. So you don't have to file papers with a surrogate's court. So if you disinherit Johnny Rotten in the trust and there are no other probate assets, Johnny Rotten will never even know necessarily what you owned and how you owned it.
Yeah.
Now he, on his own volition, can go pay a lot of money to an attorney and then try to do some discovery of that. And if the parent is proven, which is very difficult to do, was either under undue influence of another child or someone else entirely, or did not have legal capacity at the time they signed that trust, only then can they have that set aside and perhaps receive an intestate share. With a will-based administration, it is easier for the disinherited child to make hay, because when a will is or an estate itself is administered in the probate court, whether with or without a will, all the legal distributees, meaning those beneficiaries who would inherit if there is no will, are entitled to notice of the proceeding. And so if Johnny Rotten is notified by the estate attorney, yes, here is your mother has died, and you have the right to file objections either to the will or, well, in a will case, it would have to be objections. Johnny then is essentially invited to to participate in a lawsuit against the estate. Oh. It's much harder in a trust case because they're not provided that kind of.
Wow. Richard, you really gave out a lot of great advice this morning, the professional that you are. How about letting us know how people can get in touch with you and your where your offices are located, and, of course, the website again, please?
Sure thing. Yep. We're at 10 Matthew Street in Goshen primarily. Phone number is 845-291-0011. Website is mid-hudsonlaw.com. And for those interested, we do have our workshop next Thursday, July 27th at 3 p.m. You can go on our website and click on our events link and register from there if you're so inclined.
How about your website's address one more time?
Yep, mid-hudsonlaw.com.
All right. And thank you so much for your professional time. I really do appreciate it a lot.
My pleasure, Bob.
Okay, you take care until next time, my friend.
Same here.
Okay.